So this is joint work with Rahal, and when I prepared the slides, I wasn't sure she would be able to attend, and therefore you see her again, but you have her live. That's much better than by photograph. So let me move on to what we want to do, a little bit of a roadmap. I will first try to explain our research question, why this might be interesting. It's an experiment. Therefore, I have to explain to you the somewhat complicated design and why it is so complicated. I will spend a bit more time on elaborating our expectations, the hypotheses, because we try to get at mechanism, and understanding mechanism with experimental methods is never easy. I will, of course, talk about the results and end on a few implications, a very straightforward design of the task. Why might this be interesting? Well, arguably, judicial decision-making is not a mechanical exercise. But in other words, you can't take the judge out of the equation, the judge as a person. The law, in a way, always knew that, for instance, by constitutional provisions guaranteeing that the person who is going to decide your case has to be defined before the case occurs, so that this can't be manipulated in the light of a desired outcome. But why is that so? We would argue it is so because the legal experts, the judges, have to decide about reality, not about models. So the law, as a practical enterprise, doesn't have the liberty that you first on do as a law and economics scholar, namely that you cut off 90% of the case so that you have something you can clearly decide. The typical legal case is different. It's of course not just gut feeling, it's reasoned decision-making. But you know full well that in the typical case, the facts are disputed, which is even something I will bracket in today's presentation, but also that you can't distill the one correct answer, if you believe in it, like Dworkin argues, from first principles. Even if, from a philosophical perspective, you are on the camp saying there's only one correct answer, this one correct answer is not one that you can prove to be correct by saying, here is my primitives, and from these primitives, it follows by logical calculus. So the typical legal case requires something which in the legal discourse is usually called balancing. You have to trade one normative concern against another without the benefit of a uniform normative currency. So you can't prove this to be right, but you also can't avoid doing that, because the next thing that's distinguishing law in practice from scholarship, also often legal scholarship, is you can't wait. You can't say, that's too complicated, or there's too many things that are not well understood. I sent you home without a decision. You are obliged to decide the case, even if you exactly know that you do not know enough to do that. And this is, of course, a puzzle. And we were curious how this puzzle in practice is dissolved, because conceptually, it's not hard to show that a very large majority of the legal cases is ill-defined in a technical sense, meaning that there is no first principles from which the result can be derived. And still, one doesn't gain the impression that either legal decisions are all over the place and completely unpredictable, or legal decisions are just cloaking outright political preferences. There's always the suspicion that they might sneak in. The question of bias is not irrelevant, but general perception is not that this is all a futile exercise in the first place. Rather, one thinks that lawyers do something meaningful. And the interesting question is, how on earth are they doing that? And that's what we want to study. So let me first say a bit about the way how we want to proceed. We are interested in mental process, but mental process cannot be directly observed. What we try to use is triangulation. So we try to distill from competing theories about mental process different predictions about two things, choices and observable correlates of mental process. And more specifically, what we want to use is a classic procedure from psychology, namely tests for parallel constraint satisfaction. I will explain in a minute what we mean by that, with eye tracking. So with a method that, again, is no direct insight into mental process, but at least gets a fairly close correlate of information acquisition and information processing. As I announced, the experiment is rather complicated because we want to have, and usually when I present experiments, I'm so proud that my experiment is so simple. But in this particular case, complete simplicity wouldn't do the trick. From a high level, what are we doing? We first generate evidence where people just see the case materials and are not assigned a role. Then we run them through a number of filler tasks so that they hopefully at least do not precisely remember what they did. And then we induce a choice by giving them a role. And at that stage, we then also use eye tracking, and you can't hide that you do eye tracking, so participants know we are after their eye movements. We repeat the very same case material. And again, a little trick we are playing with our participants. We want to see mental process, or as much as we can, correlates of mental process. And we were concerned that if we explain the design of the screen on which we record the eye movements too closely, that at this point our participants would already make up their mind. And then at the moment when we want to really see mental process to the degree possible, they would already be done. And to avoid that, we give them another filler task, but now with eye tracking, same structure of the screen they are seeing, but a different case. And then we come back to the original case, and that is where we record the data we are really interested in. We also try to make it more plausible for participants what we are doing, and also make them think a little harder by announcing that after they are done with this, we will ask them to give us explicit written justifications so that there's a further source that we could tap on, haven't done so as yet, namely the explicit written justifications. Actually, we have looked into them, but that was less interesting than we hoped. So that's a more graphic presentation of the main elements of the design. So we present the case first, then we have them evaluate each of the elements of the case. This is what we later need to see whether parallel constraint satisfaction is going on. And again, I will have to explain more precisely what we mean by that. Then I don't have all the filler tasks in this schematic, then the filler tasks and everything is in the meantime, and then they see the case again, and now are assigned the role of either judge or attorney for plaintiff. And then comes the critical screen where we try to exploit the fact that eye movements tend to correlate rather closely with information acquisition and information processing for gaining additional insight into the mental process. And in the end, we ask them for the explicit evaluation. So even more high level, we start with each individual not having a role assigned, they just see the materials. And then in the second stage, they are either in the role of attorney for plaintiff or in the role of judge. The stimulus material is a rather simple one. A earns 3,000 euro per month. He does not own any property that could legally be seized by a creditor. A drives in his car and passes a village. The speed limit is 30 kilometers per hour. A drives at 55. A cat jumps on the street. A brakes to save the cat and loses control of his car. We actually have not implemented in this design the blue one, should have taken it out from the slide. We have implemented the red one. The car runs into an above ground fuel tank owned by B. After the tank has been installed, construction law has changed. Today, putting the tank above ground would no longer be allowed. An expert testifies that A would not have lost control had she respected the speed limit. A's insurance does not cover damage to property on ground outside the street. Repairing the tank costs 1,500 euro. There's a risk of groundwater contamination. This is why the police orders B to dredge the ground at a cost of 43,500 euro. B sues and claims the sum of both numbers, 45,000 euro in damages. We, I think, have one German lawyer except me in the room, namely Holger Sparmann, has a background in German law. The German lawyers of course all know that case. This is a standard case from police law. And it's a peculiarity of German law that the authorities can go after the owner of the property. They don't have to go after the person who has been the direct cause for the damage. And this is exploited here. So for eye tracking, we use technology that actually looks exactly like this because it's a picture from our lab. So it's a bit intrusive in that you have to be in your chin rest, that there is new technology that doesn't make that necessary, and we have it at the Institute, but the alternative technology is less precise, so it's less accurate. And we prefer to have more accurate data, especially since you will see the screen. There is a certain amount of information on the screen, and we want to be able to really distinguish between the positions on the screen where the eye was fixed, where the fixation was. So this is what the decision screen looked like, and this is why we had this intermediate stage where we used this screen of the same organization, but applied to a different case so that we could familiarize participants with the structure of the screen without having them look at the actual items of the case we were interested in. So there is the axis and the y-axis, so to speak. The y-axis is either elements of the case speaking in favor of plaintiff's position or elements of the case speaking in favor of defendant's position. And then we have 4 dimensions in which these items can be organized. One is for the sake of plaintiff, then for the position of defendant or so it should rather say the action of plaintiff, the action of defendant, then features of the verdict and effects on third parties. And let me quickly explain what we meant. I mean, they, of course, had all been told extensively what we mean by that, so we can be reasonably sure that participants understood what was on the screen. So the plaintiff did nothing, and therefore arguably should be, it's more plausible to make the plaintiff whole than the defendant, but the defendant could object that plaintiff in a way contributed to the amount of damage in that the tank, or the oil tank, was above ground and therefore at risk of being damaged were a car accident to occur. The defendant was driving too fast, was speeding, so was violating a behavioral norm. But on the other hand, the defendant was acting in arguably good intentions in that he or she wanted to save the cat. The verdict would help plaintiff in that plaintiff, at least financially, would be made whole, but 45,000 for an ordinary person who isn't insured for that risk may be a lot of money, and we constructed the case such that this person would have to file for bankruptcy. And on the position of third parties, the plaintiff could argue that having the defendant pay in full might deter others from violating speeding rules, but on the other hand, deterrence might be excessive, so people might be too much afraid of being on the street, so there might be what often in law is called a chilling effect. So that's the 8 arguments that we want participants to think about. Measures, we have a suggested verdict. Then we look at the number and the duration of fixations on one of these 8 items. And we twice ask for the stated weight of the domain of the normative items. We first ask when they see just the materials without having a role assigned, and then we ask again after they have been assigned the role and have given us written justifications. This is a standard procedure for parallel constraint satisfaction, a mental technique that conceptualizes that in ambiguous situations, the way how people evaluate the input into their judgment is influenced by the judgment they take. So the evaluation changes in that process, and usually participants are not aware of the fact that actually they change. And we made it even easier for them not to notice that they silently change things, in that there was so much in between that it would be very hard for them to remember the exact ratings they had been given in the first place. It was an experiment with the Bonn University pool with 119 students. We excluded 8 as eye tracking data arguably was corrupted. We looked into the results if we put them back in, except for one result. They look very much the same, and this one result is clearly driven by a huge outlier. We had, since we had excluded a few, it happened to be, the exclusion happened to be non-symmetric, so we have 51 versus 60, but in the end of the day, the stress in our argument is not so much in distinguishing attorneys versus judges, but in seeing to which degree assigned role matters, so that we are not too much worried about that. They got €50 for participation. So a bit on expectations, and you could also say the way how, given that we can't directly observe mental process, also not with eye tracking, we only have correlates, that we still can exploit the network of correlates to make statements about mental process. So we look at three things: at choices given roles, at eye tracking given roles, and at eye tracking given the explicit weights. The three things we work on. Here's a table that gives you the four conceptual claims that one might have about mental process and the way how we want to get at them. So one possibility is subjective utility theory. Another is, let me just mention them for now, and I'll have a slide for each of them. Another is motivated reasoning, reduction of cognitive dissonance, or parallel constraint satisfaction. And we try to exploit that if we look at all four measures, for none of the measures, for none of the theories, we get the same pattern. So in some respects, we get a similar pattern. So for instance, here, the decision time for an attorney and a judge should be the same. And here we have claims that it differs. But if you look at all four of them, for none of them, the pattern is the same. So this arguably allows us to say something about mental process. So let me now go through them one by one. The first is subjective utility theory. I, of course, have to flag that it's not a direct application because Savage has developed the theory for factual uncertainty, and we now, by analogy, use it for normative uncertainty. But other than that, conceptually, it goes through. And if this is how participants go about it, then one would expect that they first look at the input, at the items, evaluate those items, and derive from the aggregated evaluation of those items their decision, their assessment, their judgment. Therefore, and there's no reason why the assigned role should change anything. I mean, they do their subjective evaluation, and the fact that they have a role shouldn't change how they see the case. So the main prediction from subjective utility theory is that we should not see a difference in the evaluation before the role has been assigned and thereafter. The case is, in a way, stacked against the attorney. So full compensation in this case is not very likely to be the case outcome. Therefore, one could expect that if a person has been assigned the role of attorney and is in that subjective utility framework, this is much harder for the person than if it is in the judge's position and then can just follow what he or she always thought about it. The same, one could argue, should hold for decision time. And if subjective utility theory is interpreted as a theory about mental process, and if we believe that eye movements say something about mental process, then we have no reason to expect a difference between the recorded eye movements and the recorded explicit evaluations. The next conceptual possibility is motivated reasoning. Lots of evidence showing that this is very practical. If there is ambiguity, and we deliberately introduced ambiguity in our case, then people tend to exploit it to their personal benefit. And we induce personal benefit by assigning a role, and therefore we should expect that those who have been assigned to be attorneys jump at the opportunity. So we should find a difference in explicit ratings for attorneys, but there's no need to do that for judges. Judges remain as, so for the judges, we didn't introduce a bias. so no reason for them. Again, attorneys should have a harder time than judges because they must mentally construct a way of interpreting the evidence such that it serves their assigned role. This is a prediction you can discuss. You can say for the judge, it's harder to decide because the judge is not given the outcome. You could also say the other way around. The judge is free to decide and the attorney has to overcome any resistance. So I would not make too much out of this cell. Again, in the perspective of motivated reasoning, we have no reason to expect that the mental process observed by, or the information processing observed by eye tracking is any different from the explicit reasons they are giving. To the contrary, we should think that it is exactly the possibility to reconstruct the evidence, which is how you serve your interest. So in the perspective of motivated reasoning, we should expect that eye tracking data and explicit weights coincide. A third possibility is the reduction of cognitive dissonance. Again, lots of evidence, a very old concept. The difference between cognitive dissonance and motivated reasoning is that the latter concept, the cognitive dissonance, so this concept is broader. Whereas motivated reasoning would argue, I exploit ambiguity if it serves my interest. The reduction of cognitive dissonance would say, I exploit ambiguity to bolster my self-esteem. And therefore, the mere fact that we have an ambiguous set of materials but force people to decide should already be enough to trigger the reduction of cognitive dissonance. And the mental techniques arguably are very similar to the ones one expects to be at work in motivated reasoning, namely that people reconstruct the evidence such that they get a clean picture that is in line with the decision they are about to take. So here we now, not only for attorneys, but for everybody, expect a difference between the previous evaluation and the evaluation after they have made up their mind. Here we could argue that we should see more fixations not conditional on role, but conditional on the ruling, because the case is stacked against giving complete compensation, but judges might still decide that they want to give complete compensation. And if they do, arguably it's harder to get at that outcome. And therefore, if they give us the decision full compensation, one could think that this means they need more fixations. As the situation from a perspective of reduction of cognitive dissonance is no different between the roles, we should not see a difference in decision time. And finally, again, as with motivated reasoning, we should expect that participants exploit the possibility of reconfiguring the evidence to remove cognitive dissonance, and therefore we should expect that the data from eye gaze and the explicit re-evaluation coincide. Finally, parallel constraint satisfaction, a bit younger, but now also 20 years or so old, as a concept. The critical distinction between all the earlier and this claim about mental process is that parallel constraint satisfaction is at least open to the possibility that there is a context of discovery which doesn't coincide with the context of representation. So the possibility is now conceptualized that participants first have to construct something, and that we might see with eye tracking, and then they know I'm in a position of a judge or I'm in the position of an attorney. So as a judge, I have to give a justification. As an attorney, I have to give reasons for why I claim as much as I do. And for that latter representation exercise, I might reevaluate the evidence in ways that does not necessarily coincide with the mental process I needed in the first place to make up my mind. So we can't say that the eye data and the explicit evaluations must fall apart. It's possible, even in the perspective of parallel constraint satisfaction, that they coincide. But with parallel constraint satisfaction, it at least is possible that they fall apart, whereas with the previous three claims about mental process, there is no conceptual path to finding a divergence. All right, let me now move on to the results. So first, the manipulation check. Our role manipulation worked. So this is density graphs on the left axis, and in blue, you see how much damages the attorneys claimed, and you see a few exceptions notwithstanding. The very large majority of the attorneys just went for full compensation, whereas for the judges, the red line, you see they had rather different opinions about what is the correct way of deciding the case, which is by no means surprising because the case was deliberately ambiguous. Now, the first interesting part of the evidence, that is now re-evaluation. So there's a lot of material on the slide. Let me try to walk you through. We've split the data into three groups. The left-hand group is judges, and judges who give the plaintiff less than full compensation. In the middle, we have judges who give the plaintiff full or even more than, very few gave even more than full. And on the right-hand side, we have the attorneys. The items, the 8 items, are sorted such that the first 4 items speak in favor of plaintiff, and the last 4 items speak in favor of defendant. If we now first go to the rightmost column, so to the attorneys, because there the picture is clearest, we see that the attorneys re-evaluate in terms of their explicit rulings 3 of the 4 items speaking in favor of their position. So there we have a shift above the 0 line, namely plaintiff was passive, not on speeding, interestingly, but I want to be made whole, and it would be good for society in that this kind of behavior is deterred. They also devalued significantly two of the things that might be brought up by the defendant. Namely, they said the fact that the tank is above ground and therefore the defendant exposed herself to this risk is not something we think is important. And the fact that this guy may have had a good intention to save the cat is not enough to change the ruling. And then you can go through the others. I will spend less time on the others. We didn't have that many judges giving full compensation. This is why the error bars are much higher there. And you see that except for downgrading the saved cat, nothing is significant. And we find a bit two items significant if the judge is assigned less than full compensation. So we see in the logic of coherent shifts that there is a re-evaluation of an explicit re-evaluation of the evidence in light of the ruling participants have given. Now comes the, which we think most interesting part of the evidence, and when we first saw it, we were almost disappointed, at least puzzled. Namely that you can look at any of the 8 items, and you can look at any of the roles. They're just uncorrelated. So we don't find any significant relationship between eye tracking data and the explicit re-evaluations. We originally were concerned and thought, well, did our participants just not get it, or did the eye tracker not do what it is supposed to do? And actually, we have redone the whole experiment, and in this round that you now see, lots of precautions to make sure that it's not just a failed experiment. But what really convinced me, at least, most is simple data. The following table, where we try to predict whether a participant grants full or less than full compensation from either the re-evaluation of the items or from eye tracking data. And of course, it's not a full mapping, not a complete mapping, but if you look at these 3 confusion matrices, as the computer scientists would call them, you see that the accuracy isn't bad. And more importantly, the accuracy of using the explicit re-evaluation is almost as good as if we use the eye tracking data. So in these predictions, be it duration or number of fixations, we get 48 positives right and less right and full right. And here it's 49, 30, 39. So whether we use the re-evaluation of explicit data or use the eye tracking data, we are almost as well able to predict. So apparently, eye tracking data has predictive power that's almost as good as the re-evaluation data. And that brings me to the final piece of evidence, namely, in which ways do they differ? And here is, in a way, the most interesting story of the paper. If you look at the judges who gave less than full compensation, you see that they spent a lot of energy in eye tracking on figuring out whether the arguments that might speak in favor of full compensation are actually there. Or if you look at the attorneys who want full compensation, they spend a considerable amount on the argument that there might be a chilling effect and that this is something they want to have out of the way. We also find significant things where you might expect them, so where they go in favor. But what we would argue is that the process of making up your mind, constructing a coherent interpretation of the evidence, and the process of selling the outcome to your respective audience are mentally distinct exercises. And with eye tracking, we are closer to the process of forming the final judgment, whereas with what we read, we are closer to the way how I want to convince my audience that what I have decided is the correct decision. Which brings me to the bottom line. to which degree can this combination of measures allow us to infer mental process? So first, we do find reevaluation. This speaks against a subjective utility approach. Second, we find reevaluation not only for attorneys, but also for judges. This speaks against motivated reasoning. And we find that explicit reevaluations and I data are uncorrelated, but both predict choices with about the same accuracy. This speaks against reduction of cognitive dissonance and speaks in favor of parallel constraint satisfaction. So the context of discovery is a different one from the context of representation, and I said that repeatedly, is a mental moment when I try to come up with a coherent story. And on my final slide, very tentatively, I'm always very cautious to have policy implications derived from an experiment because experiments serve a different purpose. But tentatively, one might point to the fact that explicit justifications remain, of course, useful. They may have an impact on the mental process in the need to later justify is anticipated and makes the decision maker check back with explicit rules, and certainly can facilitate acceptance, and I could go on. There's a long list of good things that come from the obligation to give reasons, but our data suggests that the reasons that decision makers give are not a window into mental process. And therefore, if the law is concerned about bias or intentional miscarriage of justice, then just looking at the written reasons will probably not do the trick. So thank you very much, and I'm looking forward to the discussion.